them. You know what my colleagues say? They say 6 months off the bat. You mess up on probation, that's 6 months in jail. They don't care about your daddy coming. They don't care about you crying. They don't care that you're 24. They don't care about any of that. You mess up, 6 months. And that's overall everywhere you go. I am the nicest one. Down the hall, they probably going to give you 6 months if you mess up on probation. I'm the nicest one. And you have messed up with me and tried to play me 3 times.
This is a probation violation hearing that should have ended quietly weeks ago. The defendant is 6 days from freedom, standing before a judge who has already given multiple chances, multiple explanations, and written instructions. What's at stake here isn't just a short jail term, it's credibility. Once a judge decides someone is no longer confused but choosing not to comply, discretion disappears fast. Watch closely how patience turns into calculation, and how a probation case stops being about help and starts being about limits.
Third hearing, I'm not sure what's going on, why we can't get it together. So it's one second, I'm trying to pin you. There we go. So probation has indicated that, well, you were here on the 6th day of October 2022 for driving under the influence. You were sentenced to 12 months probation. You have 6 days remaining on probation. Your sentence was not told. Says that you failed to avoid injurious and vicious habits. You tested positive for alcohol and marijuana. You failed to complete an alcohol and drug test, failed to complete an alcohol and drug evaluation. You failed to provide proof of completing a risk reduction order, risk reduction course as ordered. You failed to complete 40 hours of community service. You failed to do anything, Ms. Little. Well, what's going on?
Your Honor, if I may, I think the confusion, at least with this last bout of probation, was that Ms. Little thought that she had No,
Miss Hahn, Miss Little and I have had conversations before. She stood before me. This is her 3rd time. I can't be that dumb, or she can't be that dumb, because I know I speak well enough so that people understand me. I don't even put legalese in it. I break it down so people know exactly what I'm saying. Miss Little has decided she doesn't want to hear what I'm saying, or she doesn't want to understand because the alcohol is too good to her and the drugs are too good to her. So, unfortunately, I only have 6 days for you to stay in jail.
And my thought is that she served 6 days already since she's been in.
That's if I decide she served 6 days.
I understand, Your Honor.
Because Miss Little is just playing with me at this point. Didn't her daddy come in with her the last time?
Yes, Your Honor.
See, so I remember. I know Miss Little is just playing with me at this point. She got all the good heart, but she can't get my stuff done.
The only thing that I didn't do was the classes. And when I went to see the probation officer, she told me that even if I couldn't finish them by December, I still had to take them because I didn't have a job to pay the $400 or the full $400 to do the courses. But when I was in here last time, my dad had brought the receipt from my evaluation, and he told him to take it to probation services. And I did the 40 hours the first time that I had came.
Where's the proof, ma'am? You didn't prove it. You don't have it. You didn't do it. It's not just do it. It's do it and show proof to probation.
Your Honor, she indicated to me that the person that she did the community service with had told her that she was sending it over, but she understands that she should have followed up to make sure that they received it, or perhaps not herself.
Hold on, Miss Hunt. Miss Little, how old are you?
24.
Miss Little, you about to mess your whole life up. I'm just saying, because first of all, you can't stay away from alcohol and drugs, which means you have a problem. Second of all, you have a problem of willfulness, because you just gonna decide what you gonna do. You're not gonna listen to me. And I know I speak clearly because, like I said, I don't use a whole lot of legalese, and I tell you point blank period what I want you to do, as the young people say. But you brought your daddy in here and he cried on your behalf last time, and oh, you know, help her. But you're gonna have to help yourself, because you're gonna end up back before me. And if it's not me, it's going to be another state court judge. And let me explain to you, I'm the nicest one out there. I meet with all the judges twice a year. We have a conference. And when we start talking about sentencing for things like DUI and messing up, I say, okay, well, I expect somebody to mess up if they have an alcohol problem. So they're going to be back here. So I'm going to try and work with them. You know what my colleagues say? They say 6 months off the bat. You mess up on probation, that's 6 months in jail. They don't care about your daddy coming. They don't care about you crying. They don't care that you're 24. They don't care about any of that. You mess up, 6 months. And that's overall everywhere you go. I am the nicest one. Down the hall, they probably going to give you 6 months if you mess up on probation. I'm the nicest one. And you have messed up with me and tried to play me 3 times. This whole, I didn't understand. I thought we were this. I thought, no, ma'am. No. I put it in writing. It's in writing.
Legally, this sounds like confusion. Psychologically, it's resignation. The defendant isn't arguing the order. She's treating compliance as optional. That may feel emotionally safer than admitting ongoing control problems, but in court, it's dangerous. Judges interpret repeated non-follow-through as willful defiance, not inability. Once that label forms, leniency becomes irrational from the bench's perspective.
So if you didn't understand, it was in writing. I do that every time I talk, I put it in writing. So if you won't read to understand and you won't ask questions to understand, that means you just want to do what you want to do. And so whatever the sentence is, she's going to spend these next 6 days in jail. What did y'all agree to?
The balance to be revoked, Your Honor.
Yep, that's it. But I'm not giving credit for time served since lockup. She gonna do 6 days.
Yes.
Don't feel bad for her, Miss Hahn. This is her 3rd time. If she felt bad for herself, she would get it right.
I understand, Your Honor.
You feel worse for her than she does. She gambled and lost. She played me. This is the 3rd time trying to play me. No, ma'am. No. Because what I don't need is you continuing to think that you can get away with something.
So, Your Honor, I guess
she's gonna serve 6 days, and her case will naturally expire.
Okay.
But what, Ms. Hahn?
I was just wondering if today counts as the first day or tomorrow. But the other, Your Honor, would you be willing to do 5 days? So Ms. Little let me know that today was the day that, so I don't know if Your Honor remembers that part of the concern for her family was that her mother, she cares for her mom.
Yeah, she's a caretaker for her mother. But if that were the case, then she wouldn't be out drinking and doing marijuana, because it would be more important for her to care for her mother.
I understand, Your Honor. I guess just the last part is that she was supposed to today have an appointment to see if she qualifies to be her mother's kidney donor.
Not with alcohol and marijuana in her system. Her mama don't need to be high. Is that kidney gonna be any good?
Yes, ma'am, it is.
Reschedule the appointment.
Okay.
They'll reschedule. But what the point I'm making to Miss Little is, you can't help your mama if you can't help yourself. You keep trying to play me.
I'm not trying to play you, Your Honor.
Because I just don't understand how you feel like you didn't understand what I said. And it was in writing. Some people say if you want to hide knowledge from folk, put it in a book, put it in writing, because they sure as heck ain't gonna read.
I didn't get it in writing until the 30th.
Well,
probation officer.
You could have asked for it. I'm unclear. Before I take this marijuana and this alcohol, let me see what the paper said. All right. So 6 days. I give her credit for today.
Thank you, Your Honor.
But Miss Little, let me tell you, ma'am. Every time you mess up in Clayton County, you're gonna come back to me. Let's not keep having these conversations, okay? We clear?
Sorry, Your Honor, I had accidentally pressed mute. You can say what you said.
Yes, ma'am. I haven't caught any other charges. This is the only time
This is the one you keep messing up on. You should have been finished with this. You should have been walking out that door, done, everything complete. You've been here 3 times. You got to try to do that. And the reason I'm suggesting that you go to NA or AA, continue to do that, because as a caretaker, that's a hard job. That is a very hard job. If you're not dealing with it well, then it will be even harder. So you need to get ahead of that. You need to start talking to some people. Now, I don't know what your insurance situation is or what you can afford for as far as counseling, but you need to get ahead of what you're dealing with. And AA or NA, you got people you can talk to and people who can share their experiences and help you work through whatever it is you're going through.
Yes, ma'am.
All right? Because I don't doubt you're going through stuff. You're just not dealing with it the right way. All right? You can go back with the sheriff.
This hearing ends with 6 days in jail, but the real consequence is what's now on the record. The judge didn't just revoke probation. She documented a pattern: repeated violations, ignored instructions, and shifting explanations. That matters far beyond this sentence. In probation cases, judges are gatekeepers of future mercy. Once they conclude someone is playing the system, every later appearance starts from a deficit, not neutrality. Notice what ultimately collapses here. Not opportunity, but credibility. The court offered structure, treatment, proof, deadlines. None of that required perfection. It required follow-through. When that didn't happen, the judge compared this courtroom to others in Clayton County, making something clear. This was the soft landing. There's also a quieter lesson about accountability. Personal hardships were raised, but the court measured them against behavior, not intention. In law, caregiving responsibilities, financial stress, and addiction struggles can explain context, but they don't erase conditions. When actions contradict claimed priorities, judges default to public safety and enforcement. This case isn't about 6 days. It's about what happens when the court decides it can no longer trust promises. From that point on, every option narrows, and the next judge may not talk this long before deciding.